Okay, so now we're recording, and I spoke a little bit about attendance, and I'm actually going to talk now about extra credit. For those of you who are interested in extra credit, I will offer you this same thing that I usually offer every semester. It's a little bit different, but pick any case that you want to analyze. You're allowed up to 3 cases, and you're going to put on a presentation for me that you're going to email me. So you'll pick a case, whether it's one we discussed in class or whether it's a different case. I prefer something from the syllabus, and you're going to spend 5 solid minutes talking about that case. You're going to give me the fact pattern. I don't need anything in writing. It's going to just be a video that I watch. It's going to be the fact pattern. It's going to be the law that's applied. It's going to be the analysis of the court. It's going to be whether or not you agree with the outcome of that case, the significance of that case perhaps. And for every case you do, maximum of 3, I'll give you 10 points for each case. So let's say you had an exam and you received a 60 on it. If you do 3 cases and you get full credit, that 60 can potentially be transformed into a 90 for that one exam. So it's a total of 3 presentations that you do, 5 minutes each, worth up to 10 points. If you send me a video that is 3 minutes long and it's actually 2 minutes of substance and 1 minute of BS, you're going to get 4 points out of 10. So just because you give me a 3-minute, 4-minute, 5-minute video doesn't mean you're going to get an automatic 10 points. Whatever substance you give me, I will give you a grade according to that substance. So it is available. You have to email me that though before the final exam. So if you're interested in doing extra credit, you must email me your extra credit assignment before the final exam. And the reason for that is once you take the final exam, I have to start calculating all your grades, and I have a certain period of time that I have to submit all those grades to the world of CSI. So I don't want to have to, it's going to take me a long time to watch all the videos and give you extra credit accordingly. So if you are interested in doing it, just make sure that you send it to me prior to that final exam. David, I think I've been getting your emails because I think I've been responding to you. If you've been emailing me at my court one, if you have emailed this one within the past 10 days, I have that on automatic reply because I'm on leave from work, from court. So, but if you've been emailing to the CSI email or my Gmail, those I've been getting, and I've been trying to respond to those if it's something that requires responding. Okay. So I'm gonna. Does anybody have any questions about the extra credit or the attendance before I get into the lecture for today? Okay.
Yeah, Professor, I'm sorry.
That's okay.
When is the attendance due?
So once you have the 10 total phrases, it's 9 phrases plus that first week. Remember, first week I took attendance.
Yeah.
So I already have your attendance for that day. So after that, every time I've given you a phrase or told you to answer a question, like for the past 2 weeks, once you have a total of 9 phrases and or answers, you can submit that in an email to me. So it might be as early as next week. So if you've attended every class or watched every lecture, by next week you should have your 9th video, possibly the week after, but it's not going to be until like it won't be the last day of the semester. You'll probably have that before unless you missed a class or 2.
So as soon as we get the 9, we email you?
Yep,
Okay.
that's right.
Okay.
Yeah.
Thank you.
You're welcome.
Uh, one more thing. Sorry.
Sure,
Does
no,
it
no
matter?
problem.
Does it matter what email we send it to?
It doesn't matter because they
Okay.
all will come to my phone. So
Okay.
doesn't matter. If you're gonna send me the attendance, I would ask that you put in the subject line attendance for, business law 160. If you're sending me your extra credit, I would appreciate if you put extra credit, in the subject line. That way sometimes if I'm searching for it, it's easier for me to find.
Okay. Understood.
Does anybody else have any questions before we get into the material for today? Okay. So today we actually start a really interesting topic. I think topics that are relevant to real life. And we start with agency. So for people who are interested in actually starting their own company or having their own business, or who are in a business relationship already, whether it be with family or friends, the underlying concept of business relationships is the concept of agency. And agency is it's like the most simplistic type of contractual transactions. Every contract or every business transaction can be created through an agency. And that this is a really important concept when we talk about partnerships, corporations, and other business entities. When we talk about partnerships between two people, partnership itself is founded on the principle of agency, because every partner, like let's say it's a partnership of two people, well, these partners are actually agents of the partnership. And partners have an authority. Each partner has the authority to bind the partnership, to bind that entity, to bind that business. And agency is just that, like, underlying principle that allows us to do that. When we talk about something higher than partnerships, because most times you think of partnership, it's a relationship between two people, right? Partnership, it's two people working together. And so the partners are working in a company, in a partnership, in a corporation, or whatever it is. Each person has a fiduciary obligation to the other partner as well as to the entity that they're working for. Certainly the same goes for corporations as well, because in a corporation, it's the officers of that corporation that are working as agents of the corporation. It's the officers and employees that are working as agents of the corporation. So agency itself it could be internal, so what happens inside an entity, a business entity, and it could also be external, what one person does to the outside, to these third parties, and what's perceived by third party entities. So when we talk about agency at its simplest, I've been using the word a lot, right? So I'm assuming you all read, but in case you have not, what's actually agency? An agency is a consensual relationship in which one person acts as a representative of or on behalf of another. So I'm going to say it again because there's actually a little bit more to it. So agency, I'll just put it in your chat. That way you have the actual definition. Copy. Let's see here, chat. Okay, so agency is a consensual relationship in which one person acts as a representative of or act on behalf of another person with power to affect the legal rights and duties of the principal. Did we talk about power of attorney in this class? Does a power of attorney sound familiar? Power of attorney, durable power of attorney? Yes, no?
I don't think so.
Okay. So have you heard the term in general, power of attorney?
Yes, I know what it
Yes.
is.
Okay. Power of attorney is kind of a common phrase. Well, I mean, I think it is, but you might have heard power of attorney. Oh, do you have a power of attorney for this person? Do your parents have a power of attorney? Does this? Well, a power of attorney is a document where one person gives rights and authorities to another person to act on their behalf. So an agent would be acting on behalf of the principal. The principal is the person who's giving the authority to somebody else to act. So when we talk about agents, agency is that relationship between two people. Now I'm going to try to spell it out in plain English for you. So it's a relationship between two people at its very minimum, where one person gives authority to another to act on that original person's behalf. So if you work in any type of business and you have an assistant that works for you, and you tell that assistant, administrative assistant, the paralegal, whoever it is, that they can sign authorizations on your behalf, well, that person is acting as your agent. They're doing things and they're authorized to do things that you would be allowed to do. So when an agent acts on behalf of the principal, any action that they take, so long as it's an authorized or within their capacity, it actually binds the principal or that business entity if they're doing it on behalf of a business. The principal, who is that main person who gave that authority, has the right to control the actions of the agent. The principal can tell the agent, you have the authority to act on my behalf for X, Y, and Z, but not A, B, and C. And so there is that authority there. There is that permissible nature of what to do and what not to do. When I was speaking about a power of attorney gives an agent potentially the ability to make any and all financial transactions on behalf of somebody else. It could allow them to take care of their real estate, their bank accounts, their stocks, promissory notes, real estate, anything financial a power of attorney can actually take care of. So when you're executing a power of attorney and you're giving authority for somebody else to handle your assets, you need to be very careful with who you're designating as a person who's handling your acting as your agent. There are limitations. You can like say, oh, no, I just want this person to only handle my real estate transactions. I want this person to only handle my stocks. I want this person to only handle, my savings accounts only for this period of time. So you can limit it, but it has the potential of being, all encompassing.
So is a health proxy also like a type of agency?
It is. Yep, exactly. A health proxy covers health related stuff. So if you designate somebody as a health proxy for you, that person is acting as your agent when it comes to health related matters. And so that's also something that sometimes, especially the past year, you've possibly heard people say, well, do you have a healthcare proxy? So if you go into a hospital and you're not able to speak for yourself, who is going to be acting on your behalf? Sometimes it's not necessary that you have a healthcare proxy. Generally, the next of kin is the person who's able to make those decisions for you. But sometimes you don't want your next of kin to make a decision for you, especially if let's say it's an elderly couple. You have a couple who's married and they're in their 80s. Generally speaking, perhaps you'd want your spouse to make decisions for you. But what if your spouse is also like mentally incapable of making those decisions? So you might want to do a healthcare proxy that designates or appoints one of your children or a friend of yours who's possibly a doctor or has some kind of healthcare background. So that healthcare proxy is exactly that. You're also designating an agent to act on your behalf. So I said this before, but I'll just say it again, that the result of the agent's actions is exactly as if the principal had taken those actions himself or herself. And the agent, as long as they're acting on the direction of the principal is going to be the one who is exposed to liability because the agent is just doing what the principal told them. So there's not so much like liability for the agent themselves just because they did something, because they'll say, well, the principal, my boss told me to do this, so I just did this because my boss told me to do it. They're not going to be held responsible for any financial setbacks or any decisions, business judgment decisions, because they're acting on behalf of somebody else. They're not the ones that are coming up with that decisions themselves. This is something I usually test on what I'm about to say, so pay attention. You can only authorize an agent to do legal things. Okay, this should be common sense, but you can only authorize an agent to do legal things. So let's say I have my agent, that somebody that works for me in my company. If I tell my assistant to go and get rid of the competition, so we could make more money, and my agent or my assistant goes out and shoots my competitor, they can't come back and say, well, my boss told me to get rid of the competition, because that's not going to cut it. Like, you cannot tell somebody to do things that would be illegal. You can't kill people, right? That's illegal. You can't do that. You cannot offer bribes to people. You cannot drugs and all that stuff. So anything that you tell an agent to do must be legal in nature. There might be charges brought up, certainly will be charges against the assistant for killing your competitor, but then there might also be charges brought up against you for conspiracy and things of that sort. You're not going to be able to pawn it off and be like, oh, well, my agent did it, I didn't have anything to do with that. The other thing I also want you to know for the exam potentially is that you cannot delegate personal services. So there are certain things that are so personal that you cannot designate like an agent or an assistant to do it. So something like artwork. if and I want to say we talked about this in the realm of contracts, right? So because again, contracts could also have the underlying agency principle. So if a family hires me as an artist to draw a family portrait, I can't then be like, oh, my assistant is going to take care of it. I'm going to designate them as my agent to do it. No, I was hired to take care of that personal um, action, so I have to do that myself. So personal services cannot be just like marriage. Remember we talked about marriage also. You cannot like, A and B are supposed to get married. The wedding, you just change your mind. You're like, oh, you know what? I need you to stand up for me and kind of like get married to this person. No, that's a very personal thing. You can't have somebody else. You can't designate that contractual relationship to somebody else. This is also something important I want you to know, and this is the breakdown of um, the two types of relationships when it comes to the realm of agency, and that is the employer-employee. So I want you to write this down: employer-employee relationship versus the principal-independent contractor relationship. So when we talk about an employer-employee relationship, it's very different than a principal independent contractor. Both are agencies. However, when we talk about an employer-employee, the biggest difference between employer-employee and independent contractor and principal is control. How much control is there? An employer will tell their employee exactly how to do their job. I want you to, if you're working for McDonald's and the manager is telling the person behind the counter, this is what you need to do. You need to flip the burgers. You need to, put the fries in the oil. You need to take care of customers right away. This is the way I want you to do it. This is the method that we have, right? It's an employer telling the employee what to do. They just have to do it. When we talk about a principal independent contractor, the principal is hiring somebody with a particular set of skills to do a job. So a hospital, when they hire doctors, they're hiring the doctors as independent contractors. They're not telling the doctor, you must perform this type of surgery by cutting open, from north to south and blah, blah, blah. The doctor has a specific set of skills that the hospital is relying on the doctor to know. So they're not going to tell them how to perform surgeries. If you hire a general contractor to build your house, you're going to tell them, if you're hiring somebody to build your house, you're going to tell them, I want a house, I want it to be this much square footage, I want the bathroom to look like this, but you're not going to go into the nitty gritty and tell the contractor, I want these pipes, this wide, and I want this pipe to go from A to B, because it's a level of skill that you don't have. So you're relying on somebody else's level of skill to do a particular type of action or transaction. Okay, so also when you have an employer-employee relationship, generally speaking, the employee is not going to be able to have the authority to bind the entire company. So the fry cook in McDonald's, they're not going to have the power or the ability to bind or make decisions that bind McDonald's. Whereas a contractor in a house, they can hire subcontractors. They can do those sort of things as long as your bottom line doesn't change. They can make certain transactions or make certain decisions that they're allowed to do. It's within their purview. Does anybody have any questions about the difference between employer, employee, and principal independent contractor?
I think we're good.
Okay, great. Okay, this is something, and I have a note here, but I don't know if I'm going to be able to test on this. This is something I usually test on, but I don't know if I'll be able to test on it with the format that we have. I'm going to tell it to you anyway. The agency relationship involves 3 basic elements. Actually, write this down. This is important because I could probably do this as a multiple choice. So the agency relationship involves 3 basic elements: assent, which is ASSENT. That's number 1. Number 2, control by the principal. controlled by the principal. And number 3, the agent acting on behalf of the principal. Number 3 is the agent acting on behalf of the principal. So
can you repeat that?
Yes.
The 3
Yep.
steps, the
I'm
3
gonna-
elements.
Yep. The agency relationship involves 3 basic elements. Number 1, assent, ASSENT. Number 2, control by the principal. And number 3, the agent acting on behalf of the principal. Okay.
Thank you.
You're welcome. I'm actually just looking at agency here. Let's talk about this one.
So the
Okay.
final is going to be it's not going to be all multiple choice.
Multiple choice and true and false, like the second exam. Okay. When we talk about also agency, there's no formalities. It could be in verbal, or it could be in writing. But if an agent is going to be acting on behalf of a principal for more than a year, that must be in writing. So just as an FYI. Okay, the next thing I want you to know is actually, which is in my notes, it's the power of attorney. So there's a difference between, and this is important to know, and this is something I usually test on. So the difference between a power of attorney and a durable power of attorney. So we said that the power of attorney handles all finances. However, a durable power of attorney allows an agent to continue acting for the principal if the principal becomes incompetent. Because it says in it, if I become incompetent, I'm in a coma, I'm not able to speak for myself, then my agent can still act on my behalf. So that's a very big difference between a power of attorney and a durable power of attorney. So make sure you know that. I always test on that. So I'm going to say it one more time. The difference between a power of attorney and a durable power of attorney is a durable power of attorney, DPOA, will still be effective if the principal becomes incompetent. Okay. The next thing I want you to know is the duties of an agent to a principal. Don't forget the agent is acting on behalf of the principal, right? So you are, in a way, if you're the agent, you're a fiduciary, you have a fiduciary responsibility. And so some of your duties are the duty of obedience, the duty of good conduct, duty of diligence, duty of loyalty, the duty to inform and to account. So in plain English, when you're acting as an agent for a principal, you have to do what's in the best interest of the principal. It's important that you act in such a way. Case law says it, tons of case law on this stuff, right? You can't screw the person you're working for. Then you're not being an agent. Then, there certainly will be ramifications, contractual ramifications, legal, civil, or otherwise. So if you breach that duty, you will have to pay for it, essentially, okay? And so it's not just, also, don't forget, don't think about it as somebody like an assistant for a principal. Also think about it in a partnership. When you have 2 equals in a partnership, right? The underlying principle is based on agency. Each principal, each partner in an agency relationship or in a partnership, they have a duty to one another because they're each acting as an agent for the entity. They're each acting as an agent to each other because it's a partnership. So each one has to be working for the betterment of the organization, has to work for the growth of the organization to try to make it, grow, and again, not screw the partner. Okay. Okay. You also have a duty not to compete. And I'm going to give you an example of this. I hear that real estate business is a very cutthroat business, right? So let's say you are working for a real estate company, and every, real estate deal, every house that you sell, you're going to get a portion of that commission, but like the company you're working for also gets a percentage, right? Because you're using their name and their resources and reputation and whatnot. So let's say you find a house or something, a listing, and you want to be able to sell it on your own so you can get the entire commission. That's you're competing now with your employer. So there is a problem with the conflict of interest between the two of you. You can only have something in your name alone if you have the blessing of the principal of that organization. If they say it's okay that you do this on your own, or if you are in a business where you're buying houses, flipping them and reselling them, and you have a partner that you're doing this with, and you find something that you want to do on your own, you can't do that on your own unless you get your partner's permission, because you have a duty to a fiduciary duty to be honest and forthright with one another. You trying to do something on the side or trying to do something that could potentially be a conflict of interest or to compete is not good. That actually breaches that duty, and there could be ramifications of that. You can't use, if you're the agent, you can't use the principal's money for your own benefit and then try to like put that money back later. Again, you can't do that. Now I spoke about the duties of an agent to a principal. You might be wondering, you're not, I know, but I like to think you are wondering, what are the duties of a principal to an agent, right? So the duties of a principal to an agent are compensation. So if you're working like as an agent for somebody, the principal has a duty to pay you, to compensate you for the work you're doing. They also have a duty to reimburse you for expenses that you put out of your pocket. And they also have to indemnify you in case you get in any type of problem or lawsuit, so long as you're acting under their authority. So it's indemnification. And the last one is good faith. They also have to treat you with good faith, not to try to screw you in any which way. Now, how does an agency relationship terminate? Well, it's very easy. If both sides decide that this relationship is not working, they can both decide, right? The principal can tell the agent, I don't want you to work for me anymore. So there could be a revocation of that relationship. And it could be done really by either side. The agent can tell the principal, I don't want to work for you anymore. I don't want to be with you in this relationship anymore. It could be done by either side. It could be done by both sides, or it could be that it ends after a reasonable period of time. Perhaps the agreement that they had was, okay, we're going to have this type of relationship for 1 year, 6 months, or we're going to have this type of relationship until we, buy this house, fix it up, and sell it. So naturally, after the house is sold, that duty is no longer there unless they decide to extend it. The next thing I'm about to say is the last thing for chapter 28, and it is something I often test on. So this is for your exam. What terminates agency? Also, it's death. Death will terminate agency if one of the parties dies, if one of the parties becomes incapacitated, unless you have a durable power of attorney. So death or incapacity, unless it's a DPOA. So that is everything on chapter 28 that I want you to know. I'm going to move on to chapter 29. Okay. So chapter 29 talks about authority. And some of it, again, should sound somewhat familiar or ring some bells to you. And that's when we talk about two different types of authority: actual authority and apparent authority. So actual authority it's like power that was actually, clearly given to somebody to act on behalf of somebody else. I designate you my agent to act on my behalf. You are clearly working for me. You work in my office. You answer my phone calls. You respond to my emails on my behalf. There is actual authority that I have conferred upon you to act as my agent. Apparent authority is authority that may not be so clear, but may lead a third party to think that there's authority actually there. So you're at a dinner party and a bunch of people are talking, and person Bob works for agency A, and Bob is talking to person Z, and Z, just tries to play it up that he works for this other company and they'd be great to work together and it'd be a great business relationship. Meanwhile, person Z has, he does like the data entry, but he makes it seem like he's all that, but he's not. So it's possible that the first person, Bob, would rely on this apparent authority that person Z has, and maybe wants to enter into a business relationship based on these manifestations that are being created. So apparent authority is like authority that you think is there, that somebody leads you to believe is there, but may not actually be there. How do we terminate an agency based on that authority? It just ends when you guys say it ends. So the termination of agency or that authority ends when the two parties say it ends, period. The next thing I'm about to say, this is something I want you to know. And again, this is going to ring bells to you, and it's about ratification. Ratification. So let's say I have an agent that works for me, and I authorize my agent only to buy things from A, B, C companies. I only authorize them to buy from A, B, and C. My agent bought things from A, B, C, and Z company. I find out that they bought things from A, B, C, and Z company. They didn't have the authority to buy from Z. But if I say, you know what, it's fine, it's okay, I've just ratified that action. I've basically said that's okay. So they didn't have the authority at first, but I okayed it after the fact. This should sound like a case we had before that involved a minor basketball player ratification. Kobe Bryant. Anyone? Were you going to say that, Carmine? Thank you. So that's ratification. It's basically affirmation of a prior unauthorized act. That's what it is. Trying to see what else I want you to know. Okay, this next legal concept is called Respondia Superior. So again, if you want to sound cool in front of your friends by, hey, I'm taking business law, I'm into law now, I'm thinking about going to law school, let me tell you about the theory of Respondia Superior, which is Latin. It actually means let the employer respond. Respondia Superior. So Respondia Superior is an employer will be responsible for the acts of the employee as long as the employee was in the scope of employment. And I'll give you an example of that. So as long as the employee was acting in the scope of employment. So I'm a contractor, and we were just hired by a family to go into their house and paint their entire house. So it's me as the boss, and I have two people working for me. We finished like 75% of the house. There's only about a quarter left, but we ran out of paint. So I tell one of the guys that works for me, hey, listen, I need you to go down the block, take the company car, and go get another couple of gallons so we can finish up the house. My agent is working on acting on my behalf of the company, the paint company. He goes and he's supposed to go down the block to pick up the paint. Rather than go down the block to pick up the paint, he goes in the opposite direction to pick up his dry cleaning because he figured he'd get it done while he's out so he didn't have to do it after work. And it was only going to take 5 minutes because he's just going to do a pickup. When he leaves the dry cleaner, he gets into a car accident with the company car. Is the company going to be liable for that accident?
No, because he wasn't acting within the scope of his employment.
Exactly. He was not acting within the scope. I did not authorize him to use the company car to go pick up his dry cleaning. I authorized him to use the company car to go pick up more paint. Had he gotten into the accident on his route to or from picking up the paint, then the company would have been responsible for that. So the case actually also that demonstrates this theory of Respondia Superior is Rubin versus Yellow Cab Company. Who would like to tell us about that?
I can talk about it, Professor.
Go ahead, Jessica.
So, Ruben, he blocked the path of a cab with his vehicle, which caused an accident. The cab driver, in response, beat Ruben with a pipe and caused him bodily harm. Ruben sued the cabbie for the bodily harm, but he also sued the Yellow Cab Company under Respondia Superior. And Yellow Cab was found not liable because the cabbie was not acting within the scope of his employment by beating the plaintiff. Yeah. So
Perfect. That's it. Yeah. So they're not responsible for the crazy acts the cab driver does. Like they hired him to drive people back and forth, not to beat them to a bloody pulp. Like they're not going to be held responsible for that. Good, very good. So Rubin versus Yellow Cab Company is or exemplifies the theory of Respondia Superior. Okay, that's all I want you to know for chapter 29. Moving right along, let me just see here what's on our syllabus. So we just have 30, 31, and 32 today. Okay. I feel like I should give you the secret phrase for tonight so I do not forget. Hold on. Okay, so for today, so attention everyone, it's secret phrase time. So the secret phrase for tonight for attendance purposes, the nice weather makes me feel joyful. The nice weather makes me feel joyful. One more time for attendance purposes for today. The nice weather makes me feel joyful. Okay, so now we're going to resume. Chapter 30. Okay. The next thing topic we're going to talk about is, again, I think this might be of interest to some of you, but it's about setting up a corporation, setting up a business. Is anybody here interested in this at all?
Yes.
Excellent. One person. I'll take it. So when we talk about business formations, if you're thinking about having your own business, or if you're thinking about getting into business with somebody, the stuff I'm going to say now is important. You should pay attention to it. So there's all different types of entities that you can actually create. You can create a solo proprietorship, you can create a partnership, you can create a limited partnership, you can create a limited liability company, you can do a corporation, and each one has different designations, each one has different obligations. Each one gives you a certain set of protections depending on what you're looking for. So when we talk about, hey, which one am I going to open? It's going to depend on the type of business that you start. The factors that people look at before deciding which type of entity to create is the ease of formation. How easy is this to do, to actually create this? Ease of formation. The next biggest thing is federal and state income taxes. Federal and state income taxes. I want to show you guys how to do this. Okay. I'm going to put this as a link in your thing. Okay. The other important factors to be aware of is external liability. How much can you be sued? So external liability. The next factor is management and control. And then the last thing we'll have is the transferability of ownership interest. How easy is it to transfer ownership interests? What I'm going to put now in the chat, actually, I can just, I'm actually going to just maybe share my screen with you. Perhaps that would be better. Share, share here. So if you're interested in actually starting a corporation, you can just go to this website, dos.ny.gov. I Googled starting a corporation in New York. And when you do that, you make sure you go to the .gov website. And if you do that, you see here, I'm highlighting I would like to, and then it gives you form a business corporation, form a limited liability company. And we're going to get into it a little bit later, like in like 5-10 minutes. When we talk about business entities, the LLC is actually the most popular one. And a limited liability companies, a lot of people say it is the preferred entity of formation because it gives you the flexibility of having a partnership, but it also gives you protection, third-party protection from creditors. So if you're interested in actually having something, you can always get an attorney for certain reasons, but this is something you can actually just straight up yourself, and it'll give you, you know, how to start a limited liability company, the forms that you need to fill out, etc., etc. So I think that's helpful in case you're interested. One of the biggest factors, and I mentioned this already, is the taxes. And certainly you need to get somebody that knows about taxes to give you, you know, more details on that. But when you start a corporation, you can have the corporation itself be taxed, or it could be taxed and then it could also pass the taxes on to shareholders. You could just pay the taxes as individuals, as a partnership. So the tax liability is going to vary depending on the type of agency or corporation that you actually start. There's also sometimes where a corporation will get taxed as a corporation, and then the taxes will get passed on to its members, and that's like double taxation. But there's also breaks that a corporation gets by virtue of being a corporation. But again, that's for a tax person. I do not profess at all to know any of this stuff, but just some limited knowledge. So when we talk about all these different factors about formation, federal, state, external liability management and stuff, well, what are now the nitty gritties? What are these actual entities are? You can have a solo proprietorship, and a solo proprietorship is basically one person runs everything. There's no formality. There's nothing that gets filed with the state or anything. It's one person and they get taxed. When they die, that company is over. It's not incorporated anywhere. So that's for the people that are like, you know, having a business on eBay, let's say, or Poshmark, or maybe, yeah, I guess that, you know, something small. It's one person, me, myself, and I doing everything, and that's it. This is our business. Okay. When you have a general partnership, it's 2 or more people that are entering into this organization. The point is to make profit. Again, there may not be any formality and there's no paperwork that has to be filed with the state. Each partner has a right to control. Now, with all these things that I'm talking about, even though that you may not have to file anything with the state, you should always, if you're going to be working with somebody else, you should always have bylaws. And bylaws are a document that doesn't get filed with the state, the government, anything. It's a document that's looked at and drafted prior really to the formation of the business. And the reason why I recommend that it's drafted prior to the formation of the business is it really gives you an idea of the what ifs. What if and it's basically a set of rules and guidelines for the entity, for the business. And so it could be done with the partnership, it could be done with a corporation, it could be done with any level of business. And the reason why I think it's so important is you get the conversation started between you and your business partners. What if this happens? I'll give you an example. Everybody goes into business thinking they're going to make a ton of money, and they'll be filthy rich, right? That's why they're going into business for themselves. What if one person is putting in the money to start this business and the other person is putting in the skill? How long is that going to continue? The person that put the money for the startup, does that mean they never have to work a day in their life? They're just expecting a 50-50 partnership? And who designates the type of return that it's going to be? If one person is putting in all the money in the beginning, 2 years down the line, 3 years down the line, it's making $1 million when the initial investment was 50. Does the person that put in the 50,000 and has not done a lick of work, are they entitled to 50% of the profits, $500,000 for not doing anything? Meanwhile, the other person, heart, sweat, and tears are going into it. What if one of the persons dies? Does the person who's remaining get the entire thing, or does it go through the dead person's estate? How do you value if they're going to sell it off to another company? What if they're going to be bought out? Or what if it's a small little deli that now is going to turn into a chain and somebody wants to buy it out? How do you determine what the value is going to be? How do you determine if you're going to let a third person in? How do you determine if there's losses and you have to take out loans on it? Who's going to get paid first? So the purpose of bylaws is to ask all these potential questions and scenarios and have the partners think about what their answers. That way they come to an agreement as to how they're going to handle things prior into entering this relationship. And the reason again is once a problem happens, emotions now are running wild, right? And sometimes it's too late to make a logical decision. But by thinking about all the different scenarios prior and having a thought process and a rationalization for how things would be handled, you're avoiding potential problems later on. We had a case, and it's finished now, so I could talk about it, where this was a business on Staten Island. And it was basically two families, not related, two families that went into this business together. Each family had 4 different individuals in it. So it's a total of 8 people running this company. One of the persons on one of the sides, let's go with this person, he died. He left behind a partner. In his will, he left his partner his interest in the business. The 3 people here did not want to work with this partner. They offered him $1 million to go away. This person, the partner, accepted. And then he was like, hey, wait a minute, let me hire an attorney to look into it. The attorney was like, why would you accept $1 million when the dividends every quarter are $800,000? So imagine quarterly dividends, $800,000. He gets an attorney and now they're duking it out. This family's kind of just hanging out on the side. And now all of a sudden the 3 family members here are like, oh, well, we're not giving out dividends anymore. The company's not doing so good. They don't want to work with this person. There was never any contingency as to what would happen if one of these people died. What would happen to their interest? What would happen to buyout? They did not want to work with this one person. They didn't want to. And that case dragged on for years and years, and it finally ended up settling. But had it been contemplated what happens to the death of one person, they would have avoided years of litigation. So that's why it's important always to have bylaws to kind of think about these things. When we talk about, so we talked about general partnerships or proprietorship. The next thing I want to talk about is limited partnership. And a limited partnership, it's again unincorporated, as one general partner and one limited partner. It can elect, it can decide to either be taxed as a separate entity. So like the limited partnership will be taxed, or it can decide that the partners will be taxed directly. Sometimes limited partnerships are publicly traded and then are subject to corporate tax, but it depends on the type of business it is. Limited liability company, LLC. This is this type of business is the most popular to form, an LLC, and it is a limited liability to the owner. So the owners themselves are actually shielded from third-party claims or creditors because it's the company itself that would be sued if there's a problem. So the company itself gets sued. There is no, it's like a shield for the owners of the company, and each one of them can actually participate in the management of the company. So each person has management. Yes, that's right. They can't come to your house. That's right. When it's actually a limited liability company, but when it's a partnership, they can't come after your assets, especially if you secured your assets, your own personal assets, as debt collateral for these things. So that is a very big perk of a LLC. You get that protection. LLLP, limited liability partnership.
I think it's limited liability limited partnership.
Yeah, I don't even go into that because of the it's very rarely created. So if you want me to tell you a little bit about it for your own knowledge, I can, but it's, if you want to, I can if you like. But let me just finish the LLC one. So the LLC, the perks of it make it that it is the most created type of company that's out there. The next one, and then we'll get into the LLLP. The next one is limited liability partnership. And the limited liability partnership is it limits the liability of the partnership. So it gives them limitation as to how much a third party or a creditor can come after them. It is filed with the state, and the application does have certain information. And the LLLP, it is usually done, I believe, for certain types of businesses. It's not something where it's not a common one at all. Sometimes it's done, I think the most common is like with a law firm where you have some kind of professional aspect to it. But then also when you have a professional aspect things, you can have like a PC, which is a professional corporation. LLLP gives you limited liability, but it also gives you the ability to have more say than you normally would with a limited partnership. But again, I'm not going to test on that. I'll say I'm not sure what, I'll probably ask some general questions about factors affecting choice, and perhaps what is the most common type of company that's created, and now you know that it's the LLC. A corporation is the last entity that I'm going to discuss, and a corporation is a legal entity completely separate and distinct from its owner. So there's a complete wall off between the liability of the individuals running the entity and the corporation itself. It's as if the corporation is an individual, and any and all liability, profit, or anything goes through that corporation. The only time the partners or the owners can get slammed if there's absolute negligence or fraud or misappropriation on their behalf where they did it. And so it's not fair that a corporation shields them from this type of liability, and so then they could be held liable. But regular business judgment, there would be no recourse or no way to get into the owners or the shareholders of a corporation. Again, the duties in a partner, from one partner to the other in all these entities, is that fiduciary duty, that duty of loyalty, obedience, and care, because you have the utmost responsibility to care for your partner. Okay, so that's that. You have a duty, you share in the profits and you share in the losses. Your bylaws can designate how that's broken down. So if you say that, listen, I'm putting in all the money, but I know you're doing all the work, I should be a 30% owner, you should be a 70% owner, that's in the bylaws. Otherwise, if the bylaws or in any of the documents you have, if it doesn't spell it out, the default is going to be 50-50. So you're sharing in the profits 50-50, and you're also sharing in the loss 50-50. And that's everything I want you to know for chapter 30. If there's no questions, and I'm going to move on to chapter 31. Anyone? No? Oh, guys, I'm actually looking at the syllabus. We only have today and then next week. And then we have a class just for like makeup questions and stuff like that. So in case we miss anything. So how are you all doing? You're still good? You're still with me?
I'm alive.
Alive. Excellent. That's what I like to hear. I'm not killing anybody with this lecture. So we'll move on. Thank you. Thank you for the people saying yes, we're live. So now we're going to move on to chapter 31. And chapter 31 is you've created your business and now you're ready to dissolve it. You're ready to close it down. So we're moving right along from one thing to the other. So chapter 31 is operating the business and dissolving the business. So sometimes, businesses don't do as well as they had hoped to, and it's time to kind of close up shop. And unfortunately and sadly, over this past year, that has happened too often. It's sad. It's very, very sad, especially when it's like small stores where you're kind of like driving past a certain store, a road, and you just see like all these closed stores. So, how do you do it? And when we talk about a business partnership shutting down or a corporation, a lot of it is the same way that things are going to be shut down. Sometimes you have personal liability if it's a limited partnership or if it's a LLP or things of that sort, where you are personally liable for debts owed to creditors. And if you have put up your house as collateral or you put up something that you own as collateral, the creditor can come after that to try to get their money. And when we talk about a liability of, you know, incoming partners, or let's say you brought on a third or a fourth person to try to kind of help you dig yourself out of the business hole that was created, that person ends up also becoming liable for how much their contribution will be from that point on. When we talk about winding up or winding down the business, this is something I want you to know. When you wind down the business, how do you actually wind down the business? Well, you kind of have to look at how much money do you have, how much debt do you owe. And when you are winding things down, you want to know how much debt you owe. You want to take an inventory of all the assets. You reduce the assets to cash so you can pay off the creditors. Perhaps you have things that you've leased inside your store that you're going to be returning. But if you bought certain things like equipment and whatnot, how do you sell that? Well, sometimes you just sell it on Craigslist or hold some kind of like online whatever to like sell the stuff so you can get money. That way you can pay off your creditors. You want to audit your books. You want to see how much money that is owed to you. Maybe there's people that actually owe you money that you can collect and help pay off your debt. You then, any remaining assets, if you have any actually plus, you're not in a negative, you would distribute those assets in accordance with the bylaws in the partnership. So the 30% owner gets 30%, 70% owner gets 70% or whatnot. The dissolution itself can be brought out by the partners saying, hey, this is not working out, we're not making anything, we're each month we're losing more and more money, it's time to call it quits. It could also be brought up by just a court order or operation of law, and there's an order that says you just have to close up shop, you owe too much money or whatnot. And sometimes, because partnership is a personal relationship, any partner can say, I'm calling it quits, or I'm going to sell my interest, or whatnot. You look at the operating agreements, you look at the bylaws to see how that can be done. Let me just see here, what else? Okay. So that's it. That's all of the stuff I want you to know for chapter 31. For chapter 32, this is like listening stuff. So if you're actually filing a something with the state, that way you can have like an actual designation of an entity created. It's usually a certificate, and in the certificate it'll say what the name of the entity is, the address and office of the organization, and the business address for each partner, and anything else that you want to include. But it has actually very, very limited information on there. Usually, again, the operating agreement or the bylaws will have how the business is actually run. When you have a corporation, something I forgot to mention, if you're doing a corporation involves a certain set of formalities. And if you dilute those set of formalities, you actually erode the protection that is given to you if you have a corporation. So a corporation, you're supposed to have, like, meetings on a regular basis. You're supposed to file taxes on a regular basis. Everybody's supposed to file taxes, but you're supposed to have like accurate record keeping, minutes of meetings and things of that sort. And if you're doing like things with a family and it's like hunky dory, we're all family, we're all friends, we're not going to do any of that stuff, then you're actually eroding that protection, the formality that a corporation gives you. So if you're going to have a corporation set up, you want to make sure you have minutes, you want to make sure that you have bylaws, you want to make sure that you have regularly scheduled meetings, because if there ever comes a time where you're going to be sued, you want to be able to use that protection of a corporation that it gives you. There's something I wanted to talk about, but I don't know if it's here or hold on. Okay, yeah, it's chapter 33. Okay. Okay. Contribution, talking about that. Voting rights. Okay. Voting rights. Voting is, I talk about voting all the time, like in elections and stuff, but when you also have a corporation or entity, it's so important to vote. And you have your bylaws or your operating agreement will have information about voting rights. And the reason it's so important is you can actually totally get screwed if depending on how you have it, done. If you have a business that you have, let's say, 10 voting members. 10 voting members. This is a corporation, it's 10 people, or even we'll do even a smaller business. Let's say you have, 7 people or 8 people running it. And you say, all right, in order for us, every time we have a meeting, we're going to have quorum. I think I'm getting ahead of myself. I think this stuff is chapter 33. Hold on. Because I love this stuff so much that I just want to talk about it, but I also don't want to get ahead of myself. Where's my... Okay, yeah, all right. I'm not going to talk about it now. It's later to come. So I'm going to control my urge to talk about it, but I'm going to just talk about voting generally. So when you have voting rights, your members or your board of directors or whoever you designate can have voting rights. It's important to designate who gets what and proxies and things of that sort. You want to have your books and your records always accurate and always kept up to date. And distributions will always be made, supposed to be in accordance with whatever the bylaws or operating agreement says, unless you're paying back loans or something like that, which you took out. About that, talk about that. Okay, so that's actually all the stuff I want you to know for chapter 32. Huh. That's it. Okay. Does anybody have any questions? Does anybody have any questions or something you want me to go into more detail? Anyone? You're good? Nope. Nope. Okay. Okay, well, with that said, thank you all for your resounding no's that there's nothing else that you want to know or learn about. Next week, I just looked at the syllabus. Next week is actually going to be our last lecture. I can't believe it's going to be May already. Wow. So next week, we're going to talk about chapter 33, 34, 35, and 36, and that's going to be the conclusion of the semester. Can you believe that? So yes, time does fly. If you have any questions about anything, you can email me as usual. And actually, Professor, yes, Jessica, yes.
I was just wondering, it's kind of off topic, but within the anyway. So,
Okay.
what do you think of the lawsuit that Nike just recently had?
I don't know anything about it.
Oh, okay.
Tell
Never
me.
mind. It was so basically I don't know if you've ever heard of the rapper Little Nas. He did the Old Town Road song that was on the radio like everywhere. Anyway, so he recently had a collaboration with a clothing company called Mischief, which essentially takes Nikes. They purchase Nikes and then they alter them. Which they've been doing this for a really long time. So they did this with Little Nas. He recently put out a video that was interesting. It was good, but it was interesting. And so in theme with the shoes that they put out, the shoes were kind of demonic. Like they had so they had like a pentagram on where the laces were. There was supposedly like a single drop of human blood in the sole of the shoe. And there was only going to be 666 of them produced. They literally sold out within 1 minute, like for pre-order, instantly sold out. But Nike actually sued Mischief for using the Nike swoosh, even though they had already purchased the shoes. So it was an interesting case. So I was wondering if you'd heard about it, because it was big in
I've
the.
not. Yeah, all these young people song things and Mischief, and I don't know anything about that stuff. But so if you are going to be, I think if you're going to be eroding or, you know, tarnishing a company's reputation by doing that, perhaps that's the only thing I could think about that Nike would be suing for, because they are like, you know,
Nike
their
actually won. They
reputation.
won the case. Nike
Yeah,
sued
okay.
Mischief and they won. And actually, all the people who had purchased the shoes had to return them.
Wow.
So it was a big thing. But what was interesting was that Mischief had done, again, Mischief wasn't a new company. They had done stuff like this before. So they had actually done like a pair of Jesus shoes in the past.
Jesus?
That were like, it was basically like there was like an ounce of holy water in the heel. There was cross, like it was like that kind of symbolism, but reversed. And they also, like, a lot of people were angered about the shoes. Like there was a lot of controversy over them, but Nike didn't sue them in that situation. So it was just interesting to see them sue for one but not
And
the
not
other,
the other.
maybe because it
I
got.
think it's like when you're associating, if it has a negative connotation and it's hurting the brand, perhaps that's why they won on that, because you can let somebody use your songs, or you can let somebody use your material or your brand or your the stuff that you've created, but it's usually under your auspices. You would have agreed to it in a certain way. And so if they're going to change that and it's going to possibly negatively impact your overall image, then I could see why they would sue for that and win and be successful. So
yeah, it was interesting. I was just wondering if you had heard anything about it and what your opinions on it were.
no, I'm not. I would. That's not my realm. That's not my area. But if it comes along, now I'll actually know about it. So, but that's good. Thank you for letting me know. Now I feel like I'm cool and hip that I know these things.
All right.
Anybody else have any questions? On topic or off? No? No? Going once? Going twice? Okay. Well, good night, everyone. I will see you next week.
Have a good night, Professor.
Good night.
Good night, Professor.
Good night.
Take it easy.
You too.